Welcome back to the Deep Dive. Today we are doing something a little different, a custom deep dive into the medieval English world, specifically the 13th century.
Hmm.
And it really is a study in extremes. Our whole premise today is simple.
Hmm.
How did this society define who belonged and who is completely, utterly outside the law?
That really is the core tension we're going to explore. Most people think of medieval life as being governed by the king, full stop.
Right, the King's Law.
But for the average villager, order was maintained by this almost dizzying overlap of different
Okay,
jurisdictions.
so what are we talking about here?
Well, you had the high, brutal royal law that defined serious crimes, what they called felony. Then you had the spiritual authority of the church, which governed morality.
And then the third one?
And then, and this is the one we'll really get into, you had the intimate, very localized power of the manorial court, the Hallmote.
So our mission for you today is to unpack this legal ecology. We're going to start at the most terrifying edge of it all, the legal metaphor of the outlaw, the man who was literally given the status of a wolf's head.
A truly chilling concept.
And then we're going to dive straight into the surprising, messy, and intensely bureaucratic reality of the local parish and that powerful Hallmote court.
It's the ultimate paradox of medieval order, isn't it? How the law could define total non-existence for one person, while at the same time defining the tiniest rules for daily existence for everyone else.
I think we should just jump right in. Let's start at that edge, that legal cliff.
Let's do it.
Okay, so let's unpack this. The most dramatic and frankly horrifying legal status one could end up with, being declared an outlaw. Or, as the sources put it, achieving the status of the wolf's head. We're talking about a complete legal death here, aren't we?
That is the perfect way to put it. It was a civil and legal death. The Latin term, which you see in the law books, is caput lupinum.
That means?
May he wear a wolfish head. And you have to understand, this was not some literary flourish or a casual nickname for a bandit in the woods.
This was official.
This was a specific formal legal definition. It was applied to someone who'd committed a felony, a serious crime like homicide or grand larceny, and had then refused 3 times to answer the court's summons.
So by refusing the summons, you're basically rejecting the king's authority altogether.
You're rejecting the entire system, and the moment that status is formally declared, the transformation is immediate and absolute.
What happens?
In the eyes of the law, that person ceased to be human. They were equated entirely with a wolf.
A wolf. Not a fox or a bear, but a wolf.
A wolf, which the sources consistently define as dangerous vermin, an enemy of all society that preys on livestock. By rejecting the king's peace, the outlaw had put himself outside the social contract. He forfeited all royal protection.
And this is where it gets so shocking. The specific choice of the wolf. Why did that analogy matter so much legally?
It came down to a really critical legal distinction. It's all about medieval hunting laws.
Okay.
So killing an outlaw was not murder. In fact, it was seen as a public service. And to understand why, you have to know that if you killed a protected animal, say a deer or a boar, even if it was in your field eating your crops,
You'd be in serious trouble.
you could be maimed or even executed for poaching because that animal belonged to the king or the lord. But the wolf. The wolf was the only beast in medieval England that could be killed by anyone, at any time, on sight.
Regardless of whose land it was on.
Regardless of anything. So the status of Caput Lupinum was an explicit instruction to the community. It said, you can kill this man. Killing him carries the same legal weight as killing the one animal that is universally hostile and totally unprotected.
So the law is literally recategorizing a human being into the animal kingdom.
Exactly. Into the most despised category of wild animal. It's a declaration. Treat this man as you would a wolf. He is outside the king's peace and may be summarily slain by any person without fear of prosecution.
And this wasn't some new Norman invention. This idea has really deep roots in English law, doesn't it?
Oh, it's foundational. The concept appears in the laws of Edward the Confessor, which predate the Norman conquest. We're talking mid-11th century.
Wow.
And those laws state that the man who refuses to answer to justice, his mouth was the mouth of a wolf. It's an incredibly durable concept, and it shows that this idea of social severance was there from the very beginning of common law.
And the practical implications.
Yeah,
It meant a total loss of everything.
complete forfeiture.
Yeah.
Not only could you be killed on sight, but you also legally died, so all your property was gone. Your goods, your movables, they went straight to the king. Your land often reverted back to the manorial lord.
And they even incentivized it, right?
Yes, the state actively encouraged your demise. In some periods, there was an outright bounty paid for an outlaw's head, just like you'd get for a real wolf's head.
So even in the 13th century, the period we're focusing on, the great legal minds like Henry de Bracton were still confirming this.
Oh, absolutely. Bracton, who was writing in the mid-13th century, confirmed it unequivocally. He wrote that outlaws bear the wolf's head, gerent caput lupinum, and could be slain by anyone.
But he did add a small caveat, didn't he? A slight softening.
A very slight one. He recognized how severe the rule was, so he added that they could be killed, especially if they were resisting capture or actively fleeing from justice. It's a tiny shift, but it's a shift.
So the legal thinking was basically, if a man rejects society, society is no longer obligated to recognize him as human.
Precisely. It was the ultimate mechanism of societal expulsion. The terrifying part is that it wasn't a punishment handed down by a judge. It was seen as a consequence of the outlaw's own decision to flee.
He brought it on himself.
The moment he fled, the law viewed him as self-punished, and therefore killable.
But as you said, there's this slight softening. The sources suggest this incredibly harsh kill-on-sight rule begins to fade over time. What drove that change?
Well, partly it was the growing sophistication of royal justice, and I think just a general sense that having citizens killing each other in the woods wasn't exactly great for public order.
A bit too much anarchy.
A bit too much, yes.
Yeah.
By the 14th century, specifically under Edward III, they introduced statutes to clarify and restrict the rule. They realized that declaring every runaway felon fair game was creating too much chaos.
So what was the practical difference after Edward III?
It was no longer legal to just kill an outlaw because you saw him wandering through the forest. You could only kill him if he was actively resisting arrest or posed a direct demonstrable danger to you or the community.
But the core legal status,
Right.
that didn't change.
No, the core status remained the same. He still had zero legal standing, couldn't own property, couldn't sue anyone in court. The law simply stopped demanding his instant death at the hands of every citizen. It shifted the burden back onto royal officials.
It's an incredible anchor point for our discussion. That is the absolute extreme of the law, the definition of non-existence. So now we have to contrast that with the systems that govern daily life, spiritual life, communal existence, the systems that defined who you were.
That's a perfect pivot. If the first part was about being entirely outside the law, we now have to move to the central, pervasive institution that bound the community together, the church.
And the parish, which by the 13th century, as you said, was basically the same thing as the village geographically.
Almost always. And this spiritual law, it was inescapable.
What's so interesting here is that the foundation of a medieval church was often less about piety and more about, well, economics, about real estate, this idea of the proprietary church.
That's spot on. You have to get your head around the fact that medieval churches were this strange mix of public mission and intensely private ownership.
So they weren't all built by the community for the community.
Not at all. Many were essentially private enterprises. They were built by wealthy landowners, laymen, monasteries, bishops, on their own property. We have a great example from Ramsey Abbey. When it acquired the village of Elton in 1017, the property deed explicitly included the church and the priest.
So the church was just another asset like a mill.
It was. The owner treated it as his personal property. The revenues flowed into his pocket, and crucially, he appointed the priest. And this leads us directly into the chaotic reality of rectors, vicars, and the financial schemes that defined the medieval church.
It sounds like a system just designed for abuse.
It was. The Lord would appoint the rector or parson and grant them the parish as a living, a source of income. And the core problem was rampant absenteeism.
The rector just wasn't there.
Often, no. He might be living in London or studying in Oxford or maybe serving in a noble's household. So he'd hire a much cheaper, much less educated deputy, the vicar, to do the actual day-to-day spiritual work.
Which basically institutionalized a class divide right at the altar rail.
It absolutely did. The vicars, the guys doing the actual work, were often local men. Sons of free peasants or craftsmen, maybe. They were tied to the village. But the absentee rectors, they were frequently the younger sons of nobility.
So they were ordained just to get the income?
For them, the parish was purely an income stream, not a spiritual calling. It was a way to provide for a son who wasn't going to inherit the family lands.
And we have some just staggering examples of this corruption running completely out of control. The name that comes up is Bogo de Clare.
Ah, Bogo de Clare. He is the poster child for institutional greed. He was the younger son of an earl and a notorious pluralist.
Meaning he held multiple church positions at once.
Multiple is an understatement.
Yeah.
In 1291, the records show he held 24 parishes, or parts of parishes, plus other positions. All told, this generated an income of £2,200 a year.
Which in the 13th century was.
A princely sum. To give you some perspective, an ordinary knight might have an income of £20 a year. Bogo was operating at the level of a major baron.
And it's the specific details of his spending that really bring this home for the common villager, right?
They do. They reveal the utter indifference of this wealthy clergy. The sources confirm that Bogo de Clare spent more in 1 year on ginger,
On a spice.
on an expensive luxury spice, than he paid the substitute vicar who was actually serving in one of his parishes.
That's unbelievable.
And the physical state of his neglected churches was a public scandal. A visiting monk found one of Bogo's churches on Easter Sunday, and he reported that above the high altar, where there should have been proper ornamentation, there were only dirty old sticks spattered with cow dung.
So if you're a villager in that parish, you know your rector is spending more on seasoning his food than on the care of your soul. How does that not just destroy your faith in the institution?
Well, it created deep cynicism. You see it in the anti-clerical sentiment that pops up in the records. The church is supposed to be saving your soul, but on the ground, it's acting like a feudal tax collector for some absent elite. You still had to pay your tithes, but seeing the church itself physically neglected must have bred a lot of resentment.
Did the church hierarchy try to do anything about this? Were there any genuine attempts at reform?
Oh, yes. There was a constant pressure for reform, even if it wasn't always effective. They tried to limit the number of benefices one person could hold. More importantly, Pope Alexander III, back in 1172, decreed that vicars, the men doing the work, had to have job security and an adequate stipend.
Living wage, basically.
A living wage, often fixed at a third of the church's total profits. But, powerful families always found ways around the rules. The ideal was reform, but the reality was Bogo de Clare.
So let's talk about that revenue. The sources lay out 4 distinct streams of income for the church, which really shows how deeply it was embedded in the local economy.
The first stream was a collection of small ancient charges. Things like plow alms, which is a small tax on each plow team at Easter. There was soul scot, a kind of mortuary gift you gave the priest when someone in your family died.
Like a death tax.
A kind of spiritual death tax, yes. And church scot, which was paid by free men in grain. These were small, but they were mandatory.
But the main engine, the biggest source of income, was the tithe, the obligatory tenth.
The tithe was everything. It was essentially a compulsory income tax on everything you produced. And the Ramsey Abbey records give us this incredible granular detail.
It wasn't just on grain.
Oh no, it was on the great sheaves, wheat, barley, oats, rye, but also on 1/10 of the milk your cows produced every single day, 1/10 of the wool from your sheep, 1/10 of your pigs, your geese, your garden vegetables. It touched every single part of your economic life.
And they had a really precise system for making sure they got that exact tenth, even for small numbers of animals.
The rigor was astonishing. For livestock, like sheep or kids, if you had 7 of them, the rector would take 1 animal, and then he'd make up the difference in silver coin to ensure he got the full value of 1/10.
And if you had fewer than 7.
He'd just take the value in silver. This was not an optional donation. It was a rigidly enforced tax designed to extract the maximum possible value from the village.
The third stream was oblations, which were technically voluntary offerings.
Technically voluntary, but socially mandatory. You gave these at mass, at weddings, at funerals, and they were often paid in kind, which really reflects the peasant economy.
So things like eggs?
Eggs at Easter, cheese at Whitsuntide, chickens at Christmas. We have a lovely example from one village where, on a feast day, parishioners gave loaves of bread. But only 1/3 went to the church, 2/3 went to the paupers of the parish. So you do see the church's role in local charity there.
And finally, the fourth stream. The rector wasn't just a priest, he was also a farmer because of the glebe.
The glebe was the land attached to the church. The rector held it as a free man, which was crucial because it meant he was exempt from the labor services that villeins had to perform for the Lord.
So he had his own farm.
He had his own farm, and it was often twice the size of a standard villeins holding. And this created a real moral conflict. Reformers worried that the priest's study would become full of granges, sheep, cattle, and rents, that his focus would shift from theology to agriculture.
And we even see this conflict spilling over into the manorial court records.
We do. It's a perfect intersection. The rector of Elton was cited in the Hallmote court, not for some spiritual failing, but for digging clay pits on the common land.
Why was he doing that?
He was probably getting fertilizer for his glebe or materials to patch up his walls. But the community saw it as a general nuisance because it infringed on their common rights. That little detail just perfectly shows the daily tension between the priest's spiritual role and his identity as a local landholder.
So despite all this wealth flowing into the church, particularly to men like Bogo de Clare, the actual working clergy, the vicars on the ground, they often suffered from widespread ignorance and illiteracy.
That gap was profound. The ideal was a learned man, but the reality was often the illeratus priest. A man who lacked Latin, was ignorant of basic scripture, and often had only minimal training.
The philosopher Roger Bacon had some harsh words for them.
He launched a devastating critique. He accused these priests of reciting the words of others without knowing in the least what they mean, like parrots and magpies.
And this intellectual vacuum led to some genuinely amusing, if concerning, anecdotes.
They're wonderful because they perfectly illustrate the confusion that comes from just memorizing sounds without understanding. We hear of a priest who confused Barnabas with Barabbas.
A pretty significant difference.
To say the least. Another one confused St. Jude the Apostle with Judas Iscariot. But my favorite is the priest who couldn't grasp the parable of the two debtors from the Gospel of Luke. One owes 500 pence, the other 50.
Right.
When it was explained to him that the debts were different amounts, he insisted that the money must simply be from different mints. One was Angevin pennies, the other was sterling. He couldn't conceiving a difference in value, only a difference in origin.
So the intellectual void left by these wealthy, absent rectors led directly to the creation of these guidebooks, these cheat sheets for functionally illiterate priests.
Exactly. Necessity is the mother of invention. Works like the Oculus Sacerdotis, the Eye of the Priest, and John Merck's instructions for parish priests emerged to fill that gap.
And Merck's was especially important because it was in English.
Crucially, it was in the vernacular and in verse to make it easy to memorize. It provided a script for priests. How thou shalt thy parish preach, and what thou needest them to teach. It codified basic theology for men who couldn't read the complex Latin texts themselves.
Let's move to moral discipline. The great unhonored ideal of clerical celibacy is probably the most documented failing. It just shows the gap between the church's law and the social reality.
It was an ideal, certainly mandated by the church councils, but in the 13th century it was rarely observed. One canon lawyer at the time noted that almost none observed the vow of chastity. Concubinage was common, often open, and generally accepted by the local community.
The villagers just saw it as normal.
For the most part, yes. They often viewed the priest having a partner and a family as a normal domestic situation.
And this practice generated both these terrifying cautionary tales and also some surprisingly pragmatic stories.
On the one hand, you have Robert Manning's chilling moral tale. The story of the woman who lived with a priest, had 4 sons with him, and when she died, a host of fiends seized her body from the wake and dragged it away to hell without end forevermore.
That's a pretty clear message.
It is powerful propaganda designed to terrify women out of such relationships. Her son, the story goes, then roamed the world advising women not to become priests' mares.
But then you have the reality where the enforcement just breaks down.
The Lanarkos Chronicle gives us the perfect example of pragmatism winning out. A vicar's concubine hears the bishop is coming to demand her dismissal. So what does she do? She intercepts the bishop on the road with gifts of cakes and eggs.
A bit of bribe.
And a bit of wit. When the bishop asks where she's going, she says she's taking the gifts to the bishop's mistress who has lately been brought to bed.
No!
Yes. The bishop was so mortified that he completely dropped the subject of celibacy when he visited the vicar. It just reveals how widespread and utterly normalized the practice was, even for those supposed to be upholding the standards.
So let's turn to the actual experience of worship for the villager. Mass sounds very different from what we might imagine today.
Dramatically different. Everything was in Latin, which of course almost no one understood. Congregational participation was very low. You typically only receive communion once a year at Easter.
And no pews to sit in.
No pews. People stood or they sat on the floor or they brought their own little stools. And the moralists were constantly complaining about the lack of reverence. People chattering, gossiping, even flirting during the service.
So sermons, then, became the main point of contact for actual spiritual learning, especially when the friars arrived on the scene.
Yes, exactly. Sermons by the local parish priest were infrequent. But the Dominicans and Franciscans who arrived in the 1220s, they revived preaching. Their sermons were lively, engaging, highly visual.
And interactive.
And interactive. We have that famous example of the woman in the congregation heckling a preacher, shouting, "What about you? You've been babbling for the last half hour." And everyone apparently laughed. It suggests a very active, engaged audience.
And they relied heavily on what was called the exemplum, the illustrative story, to make their points.
They knew that examples move men more than precepts. These stories were used to drive home complex moral points with memorable drama.
Like the story of the woman who wouldn't forgive her enemy.
A classic, the worthy woman who refuses to genuinely forgive her enemy on Easter Sunday. She tells a neighbor she hadn't forgiven her with my heart as I did with my mouth, and as soon as she says it, the devil appears and strangles her. The moral isn't just about forgiveness, it's about the mortal danger of hypocrisy.
And if those stories weren't enough, the friars often closed their sermons with just sheer terror, with hellfire.
The terror was graphic and pervasive. The imagery they used, comparing a sinner's agony to being rolled a mile in a barrel lined with red-hot nails.
Wow.
Devils were burned in black. Hell was not just pain, but the agonizing realization of man's true nature. You are nothing but a stinking slime, and after that a sack full of dung, and at the last, meat for worms. The goal was maximum psychological impact.
But the priest's most constant job maybe was instruction and confession. He had to be a kind of moral detective for the village.
He did. He was required to teach the creed, the Lord's Prayer, the commandments, and confession was mandatory and incredibly detailed. It was a forensic interrogation of your soul, guided by these new instruction manuals.
What kind of questions were they asking?
Everything, from basic belief right down to specific behaviors. Have you done any sorcery to get women to lie with you? Have you spent Sunday in shooting, wrestling, another play, or going to the alehouse? They even asked, are you on a ride through grain when you could go to one side? Which shows that merger of moral and sort of environmental concerns.
And the penance that came out of this had to be very carefully calibrated. It shows a surprising amount of social awareness.
It does. The crucial advice was twofold. First, the penance must fit the sin. But it can't be so heavy that you just give up and ignore it. Better purgatory than hell, was the logic.
And the second part.
And second, and this is so prudent, a woman's penance had to be something her husband wouldn't find out about, lest it cause friction or even violence in the household. That small detail shows how keenly the church realized it had to operate within the delicate social balance of the village, not against it.
And finally, that fascinating story about the churchyard. The consecrated burial ground is a point of deep community identity, wasn't it?
It was sacred ground, but it was also constantly being defiled. There are all these injunctions demanding it be walled to keep out brute beasts, which leads to that wonderful story of the Norfolk villain confronting the knight.
The knight whose animals were getting into the churchyard.
Exactly. And the knight asks, why should he respect such churls' bones? And the villain's reply is this beautiful, poetic statement of equality in death.
What did he say?
He said, the Lord that made of earth earls, of that same earth made he churls. Earls, churls, all at one, shall none know your from our bones. And the knight, completely abashed, repaired the wall. It's just a powerful reminder that even in this incredibly hierarchical society, the idea of custom and common humanity still carried real weight.
That story is the perfect transition, because if the church governed the soul, the Hallmote governed everything else. We are now plunging into the primary, boots-on-the-ground system of law for the average villager. This was the true engine of local order.
The Hallmote, which literally just means the hall meeting, it was the lifeblood of the village. It was presided over by the Lord Steward, yes, but, and this is so important, the court was ruled by the powerful, unwritten custom of the manor and by the active participation of the villagers themselves.
It sounds like it was the executive, legislative, and judicial branch all rolled into one meeting.
That's a great way to put it. It was. It handled everything.
So let's define its function. It was dual purpose. It served the Lord's interests, but also the village's need for order.
Exactly. First and foremost, it was for the Lord's business, collecting dues and fees. This included the heriot, or death duty, which was the Lord's right to claim the best beast, often your only plow horse or ox, when a tenant died.
Which could be catastrophic for the family.
Instantly devastating. It also collected entry fees for new tenants, and crucially, it enforced the labor services, fining tenants who failed to show up for their required plow or harvest work.
And then there's the village business side of it.
That's right. This is where it managed the day-to-day chaos of community life, resolving disputes between neighbors, Everything from your pigs getting into my garden to you slandering my name at the alehouse. And most importantly, it enacted and enforced the local bylaws.
The rules for farming.
The rules for everything: when to plow, when to plant, when to pasture your animals, the specific rules for gleaning leftover grain from the fields. Without those local laws, the entire village economy would just collapse.
And the pace of these courts sounds just grueling. The stewards were constantly on the move.
It was intense. The Ramsey Abbey steward's itinerary shows him visiting 23 different manors in about 6 weeks. He'd often hold court and conclude all business in a single day.
And the courts themselves were chaotic.
Crowded and noisy. We have explicit records finding people for general disorder, for making a racket, talking much in court. The steward had to maintain absolute control.
The real engine of this justice system, though, the thing that gave it legitimacy, was the jury of presentment.
The jury of presentment, usually 12 sworn men, the jurati, they were the heartbeat of the court. They weren't passive observers, they were the investigators. They collected evidence, presented the charges, and interpreted the local custom.
So they were both the grand jury and the trial jury.
In effect, yes. And their power was immense, which meant their responsibility was absolute. They themselves could be fined, and fined heavily, for concealment, failing to report a crime, or for false presentment, getting a charge wrong.
And the verdict's authority, its power, came entirely from the community's buy-in.
This is the critical point for understanding why the system was stable. The jury's verdict was almost always recorded as being backed by the whole assembled community. Velata dicit, the village says, or even more definitively, per totem Hallmotem, by the whole Hallmote.
So even if the outcome was harsh, it was accepted.
It was accepted because the judgment was rendered by your own neighbors, by men you knew your entire life.
And the court had these formalities, these rituals that must have felt like a script.
They did. We have manuals like the Court Baron that prescribe these elaborate, almost theatrical scripts for making a complaint and mounting a defense. You had to use the right words. Litigants were incredibly alert to technical flaws in the language their opponent used.
And at the heart of the system, if there was no clear physical evidence, was compurgation, the practice of oath-helping. Reputation was everything.
Compurgation was the medieval equivalent of a character witness, but with far higher spiritual stakes. If a defendant was ordered to be at your law six-handed, he had to bring 5 neighbors plus himself to swear that his account was true.
And for serious cases, it could be 12-handed.
It could. And the risk for those oath helpers was spiritual damnation. They were swearing on holy relics or a consecrated book. The belief was that no sane person would risk eternal hellfire over a neighbor's stolen pig. So if you couldn't find 5 people willing to stake their souls on your truthfulness,
The court knew you were guilty.
the court knew you were guilty. It was a system built entirely on social cohesion and spiritual fear.
The system also relied heavily on pledges, or sureties, which created this wide web of communal responsibility.
Pledges were everywhere. For nearly every court interaction, both sides had to find fellow villagers to act as their sureties to guarantee they'd show up to court or pay their fine.
And if you didn't?
If you didn't, your pledge was fined instead, usually 3 pence. This meant that the men of standing in the village, the reeves, the beadles, were constantly being roped in to guarantee the behavior of their neighbors. It created a network of liability.
And despite this being a local, supposedly speedy court, delay was still a feature.
Oh, it was. The procedures were complex. A defendant could get up to 9 successive postponements, 3 summonses, 3 distraints where they'd seize your goods to make you appear, and 3 athoins, which were legitimate excuses for not showing up.
So there were loopholes.
There were always loopholes, even at the manorial level.
And if you didn't want to go through all that, you could settle out of court on a love day. But the Lord still got his cut.
Of course. It was essentially a mediated peace agreement, but you still had to pay the Lord a fee for a license to agree. The Lord made sure that even negotiated peace was a source of revenue for him.
Let's talk about a related system for policing the village. The View of Frankpledge.
The View of Frankpledge was this uniquely English institution. It was held once a year, and it was all about local accountability. All free males over the age of 12 were organized into tithings.
Groups of about 10 or 12 men.
Exactly, and they were collectively financially responsible for each other. If a member of your tithing committed a crime and fled, the entire tithing was fined. So the View was mainly about making sure those tithings were up to date, that every boy turning 12 was enrolled.
And it also had the lighter duty of choosing the village ale tasters.
It did, which connects directly to the most common offense we see in the Hallmote records.
Before we get to the ale, let's look at violence. The Hallmote dealt with assaults, and the key response was the hue and cry.
Raising the hue and cry was a massive communal obligation. If you were within earshot of that cry, you had to drop whatever you were doing and help catch the offender.
And if you didn't?
If your village failed to respond, the whole township was fined. They distinguished different kinds of violence, too. Drawing blood was especially serious. And hemsoken assaulting someone in their own home was seen as a grave violation of that domestic sanctity.
And they also policed false alarms.
Absolutely. The system needed integrity. You could be fined for unjustly raising the hue and cry. It was a powerful tool, so it had to be used responsibly.
And the punishments for these local crimes were surprisingly moderate. It was fines, not prison.
That's the crucial difference from the royal courts. Imprisonment as a punishment just wasn't really a thing. The Hallmote levied fines. Very rarely you see corporal punishment like a man put in the stocks for breaking his stepmother's hand. But even for serious injury, it was usually fines and damages paid to the victim.
Which brings us to it. The single most frequent offense in the records, dwarfing everything else.
Yeah.
Brewing.
Yeah.
And the ale, fines.
The sheer regularity of fines against women brewers, it's almost always women, is striking. This wasn't just about drunkenness, it was about the economy.
And the charges were very specific.
Incredibly specific. Selling before the official ale tasters had approved it, charging too high a price, using unsealed inaccurate measures, or selling ale that was just bad. The records describe it as weak, not a full value, or, my favorite, not worth the money.
So was this just a backdoor tax for the Lord, or was it genuine consumer protection?
It was both. I mean, given the sheer number of fines, it certainly functioned as an implicit license fee for the Lord. But the level of detail, the fact that they're checking quality, price, and measure, that strongly suggests the community was using this law to protect themselves. Ale was a staple food, a source of calories. Ensuring it was safe and fairly priced was vital.
We have to talk about the crucial tension here, the villager versus the Lord. Individually, the peasant was at a disadvantage, but collectively, the community had surprising power.
That is the ultimate tension of the whole system. An individual could be crushed. If you pleaded in opposition to the steward, you were fined for contempt. Arbitrary power was real, but the system's stability rested on custom. And when the community unified under the banner of custom, the limits of that arbitrary power were suddenly exposed.
And the Greenway dispute from 1300 is the perfect case study of this.
It is the definitive case study. This dispute involved the tenants of Elton, the villagers Free and Villain, together united against the Lord's bailiffs.
What had the bailiffs done?
They had enclosed a common pasture called a goose home, and critically, they had blocked the Greenway droveway, which the villagers needed to move their livestock. When the Lord's officials cited 9 villagers for using the Greenway, the community's protest was immediate and total.
And what was their argument? What stopped the steward in his tracks?
Their argument was simple and powerful. They swore that they and all men of the village ought by right and custom to have that droveway at all times, and that any money the bailiffs had taken for access in the past had been achieved by distraint and extortion.
So they called the Lord's bluff.
They did, and this unified, angry protest, backed by the 12 sworn jurors, put the steward in an impossible position. He realized he could not simply rule against the established custom of the entire community.
The sources say he was clearly embarrassed.
He was, and unwilling to pronounce a judgment against his own boss's official. So he punted. He deferred the whole judgment to the abbot, the highest authority. He told the abbot to examine the customs and do and ordain as he should see ought to be done.
That moment is so key.
It's the whole takeaway. It shows that when confronted by the united, sworn custom of the whole community, the Lord's man had to yield. Because overriding that custom would threaten the fundamental stability of the entire manor.
So outside the Hallmote, you still had the royal courts, and they dealt with felony, the really big crimes. Homicide, rape, major theft. And that's the system that used the death penalty.
Yes, royal justice was slow, and it usually ended in hanging, or the axe for a high-status offender. The process often began with a coroner's inquest for any suspicious death.
And this is where we get the strange legal concept of the deodand.
The deodand. It was the object that caused an accidental death. A horse that threw its rider, a collapsing wall, a runaway cart. That object was sold, and the money went to the king. Literally, a gift to God deodandum.
So it was a kind of atonement.
A kind of spiritual cleansing. The dangerous object had to be removed from use. The coroner's jury also had to appraise all the property of an accused murderer because it would all be confiscated by the king.
And we have that tiny, fascinating detail from Elton about this.
Yes, it shows the intense economic surveillance. The villages of Elton had to answer for 18 pence and 2 farthings worth of goods belonging to a danged man, a tiny, specific sum. The items included his boots, a knife, and a dog collar with silver fittings. The property had vanished, and the community was held responsible for accounting for every last farthing.
Now, if you were charged with a felony and you were facing the royal noose, there were 2 main ways to try and escape that fate.
2 key methods: benefit of clergy and sanctuary.
Benefit of clergy was.
It was a get-out-of-jail card. You claimed you were a cleric, which moved your trial to the church court, and the church court couldn't use capital punishment. Felons would literally learn a verse of scripture in prison, the neck verse, so they could prove they could read and were therefore eligible.
But you could only use it once.
Only once. Your thumb was branded so you couldn't try it again.
And the other option was sanctuary.
All consecrated ground. The church here offered 40 days of protection. It wasn't permanent safety, but a cooling off period. Within those 40 days, the fugitive had to confess, swear to abjure the realm forever, and get branded on the thumb with an A for abjurer.
And then they were just marched out of the country.
Marched to a designated port, often barefoot in a white sheet, and they had to stick to the highway. If they strayed or failed to reach the port, they immediately became outlaws. They became the wolf's head we started with.
So, to summarize the penalties across these systems, you have fines in the manorial court,
Penances in the church court.
and death in the royal court. Prison, as we know it, just wasn't really a punishment.
That's right. Prisons were for holding you before your trial, not for long-term punishment. The only real hope of appeal in the royal court was a royal pardon, which required immense influence, or a war. The king often pardoned felons if they agreed to go fight the Scots or the French.
What an incredible, detailed immersion into these layers of medieval law. We started with the absolute extreme, Caput Lupinum, a state of legal non-existence where a man was literally no better than an animal. And yet, we spent most of our time detailing how everyday life was governed by these hyper-localized, minute rules of the Hallmote and the Parish, enforced by neighbor against neighbor.
And that's the central paradox that made the medieval village actually function. Yes, the manorial system was fundamentally exploitative. You were constantly paying fines and fees. But it was surprisingly stable because the villagers knew the rules, and more importantly, they were the ones enforcing them. The steward couldn't just rule by whim when he was confronted by the unified custom of the Vallata Dicit. The system was messy and harsh, but it was predictable, and it was based on shared community enforcement.
So the average person was living within these 3 different spheres of justice, but the one that truly dictated their daily life, the one they had the most leverage in, was the one right outside their front door.
We began with the wolf's head, a man with no rights outside the king's peace whose death was a public service. Now, connect that back to the village.
Right.
Consider how much safer, ironically, the medieval villager must have felt, knowing that his immediate fate, his right to common pasture, the fairness of his ale, his ability to appeal an injustice, was determined not by the faraway king or by a corrupt, ginger-obsessed cleric like Bogo de Clare, but by the 12 men who sat next to him every Sunday, the same 12 men who were also constantly getting fined for their own petty thefts, their own slander, their own weak ale. Their justice was rough, but it was inescapable, it was communal, and it was intensely shared. And that localized custom, even more than the king's distant peace, was the true bedrock of order.